Didn't want to let me in.
We are streaming live to YouTube as well as broadcasting to the public. If you've just joined the meeting, we have attendees in the waiting room. Attendees, thank you for waiting. We were tardy in starting the meeting, but we appreciate your patience. We're just waiting for a few more board members to join us. Sorry.
You're still not the last.
I'm not really a CIO. I'm having brain difficulties, not technical difficulties. Too many links today. I was in the other meeting, I think, that Christy sent out, the public one. And so it said the host was already in another meeting, and I was like, what's going on? And then, yikes. I think that's probably what they're doing too.
They are, Rachel. Thank you for mentioning it. I'm working to get the other members joined. Please
Okay.
be patient. Thank you.
Wade's having the same problem. Too many links. If you go to the public one, you can't get into this meeting. Because we're in the host meeting, not in the public one, and that's the confusion. We normally do not get copied on the public email, and I'm sure that's what Wade did. That's what I did.
Yeah, I'm sorry, everyone. I looked all over. I couldn't find the original invitation.
Yeah.
We got one tonight.
Yeah, the original invitation, sorry for all the mix up in the links. This is, I'll take administrative fall on this one. We had multiple meeting messages go out and it caused some confusion, but thanks for working through it and joining and getting online. Let me see who we're missing here.
Don't let it happen again, Debbie.
Yeah, Linda.
We're
My
missing
name-
Lisa.
My
I'm
name
here.
is Pat.
I'm here. I'm here.
I don't see you.
I'm
Gary's
here.
on, Dale's on. So if I'm not mistaken, is Rob on? Rob. I'm literally gonna take a roll call to make sure that we have everyone we need. Rob? He's sharing a screen,
Yeah.
so I know he's on.
I'm here and I'm sharing the screen.
Harry,
I'm here.
Dale,
Here,
Wade,
Here.
Rachel,
Here.
Andrew,
Here.
Jim,
You're
Lisa.
Here.
We are all present. Thank you. Wade, feel free to start the meeting.
Okay, good evening, everyone. Welcome. I guess when with COVID and everything that's going on, it's we've broken our streak. I always start exactly on time, and I apologize that we are 12 minutes late. But thank you all to everyone who has joined us. My name is Wade Frick. I'm the chair of the Village of Chagrin Falls Board of Zoning Appeals. Tonight, it's November 11, 2020. This is our special meeting. We had 4 other items on our October meetings, and we did not want to wait until our November meeting, so we scheduled a separate meeting to hear the application of Dennis Marino on Soul Leather Lane. So again, apologies. Hope everyone can hear and the technology is working. And again, thank you to all of the team who helps us make all this technology work. So with that, if you've never been on one of our meetings, we run them the same that we do by Zoom. We do them the same way we do them on when we're in person. We're actually creating a record of the discussion, a written record. When we get to the points in time when people are speaking, if you could please identify yourself by name. I'll ask our law director, Dale Markowitz, who's with us, to swear you in. The way we handle this is I'm going to ask Rob Jameson, village administrator, for the procedural background and how we got to be where we are. There's a number of moving pieces on this one tonight, and we're going to try and take it in finite chunks. And I assure you that everyone, it looks like there's 22 participants, including us, so there are a number of people that are with us. I assure you, as I prompt you, everyone will have an opportunity to speak. So please know that. Again, thank you all very much for being here. And Christy Holmes, I promise to try and call you by your right name tonight, but thank you for getting us all the technology and helping us. So with that being said, we have one item on our agenda. It is, as I mentioned, the application of Dennis Marino, Soul Leather Lane. This has been before us before. It's gone through council. It is now back before us. So Rob, if you could please just sort of remind us how we got to be here so we can try and keep the moving pieces as separate and distinct as possible. So Rob, if you could help us to start.
Sure, thank you, Wade. You may recall this matter came before the Board of Zoning Appeals at its June 23rd, 2020 meeting in a little different fashion where there was an appeal made to overturn the decision of the Planning and Zoning Commission to grant the modifications to allow the consolidation of 3 parcels into 1 lot on Soul Leather Lane. The Board of Zoning Appeals met on the 23rd of June, and the motion to approve the appeal failed, and the decision of P&Z was affirmed. Right after that, 3 council people petitioned the village to have this meeting heard by council, have this matter heard by council, and they did at their August 6th meeting. We also received an appeal request from council representing 2 neighbors, Hope Gumprecht and Mark Rogers. So 3 council persons held the hearing on August 6, 2020. And they passed the following motion. Move to reverse the decision of the Board of Zoning Appeals, vacate the decision of the Planning and Zoning Commission, and direct the Planning and Zoning Commission to revisit the matter and condition any re-subdivision and lot consolidation approval with any required modification by the Planning and Zoning Commission on the original applicant receiving any needed variances for consolidating the lots and re-subdividing the land from the Board of Zoning Appeals. That was directly from the audio tape of that meeting. So this matter then went back to the Planning and Zoning Commission on September 21st, 2020, where they heard the application to consolidate these lots and create a lot based on the proposed lot depth to width ratio. And that motion was voted down and failed. Give me 1 second here. There's a lot of documentation here that I'm going through. Okay. The motion to deny the lot consolidation proposal was approved with a 4-1 vote. Mr. Marino then requested guidance on where he would go, where he could take his application from there. On September 25th of 2020, I issued an updated zoning review letter on the project listing the code nonconformity with the proposed lot consolidation, as well as instructions on how to submit an appeal to the decision of the Planning Commission and a variance application for his proposed lot consolidation. In my letter, I stated a deadline of Monday, October 5th, to have both the appeal and the variance application submitted back to my office. That was done. Mr. Marino submitted both of those applications to my office, and we then scheduled this meeting. On November 2nd of 2020, we received a letter from Steve Byron, counsel for Hope Gumprecht and Mark Rogers, requesting that both the appeal application and the variance application submitted by Dennis Marino be dismissed on the basis that it did not meet the timing deadline for filing an appeal to the decision of the Planning Commission. We refer to Code Section 1111.03, application for appeals or variances that give the code section language on filing an appeal. So tonight at this meeting, as we have outlined, we have several decisions before us. First and foremost, determining whether there's standing on the issue of hearing the appeal, the timeliness of the appeal, and whether that should proceed or not. If so, then we can hear the appeal. If not, that matter would be voted on. And then secondly, whether the Board of Zoning Appeals will hear the variance request to create the non-conforming lot, and whether they feel that was filed in a timely manner or not, and if so, to proceed with that matter. I know that I had sent out to the commission 3 different emails with all of the documentation and supporting letters that have been a part of the proceedings so far up to date. And if you need any specific document brought up on the screen, I can do that. I'll be glad to take any questions here before you proceed with the first matter.
Okay, does anybody on the board have questions of Rob for that extensive backdrop of where we are? Okay, Rob, thank you for all that. So it gets confusing even for those of us who may have a law degree with the appeals, the appellants, the appellees, the motions to dismiss, everything else. Let me try and make it as simple as possible to start here. So the applicant is Mr. Marino. The applicant had his application to planning and zoning denied. He's appealing to us. But in the meantime, we've received what I'll call a motion to dismiss filed by Mr. Rogers, counsel for Mr. Rogers and Ms. Gumprecht. What I would suggest, and Dale can tell me otherwise if this doesn't make sense, but what I would suggest is that the board hear evidence, if you will, on that motion to dismiss, because if we deem that the appeal by Mr. Marino was untimely, we don't even need to get to the substance of it, because if we find on a formality, if you will, that the appeal was not timely. So I would suggest taking this in order that we should start with consideration of the motion to dismiss the applicant's appeal, if that makes sense. Is that?
Yes, Mr. Chairman, I agree with you.
Okay.
I think though, the only thing I was going to say is that the parties who have moved to dismiss, they may not necessarily want to put on evidence. They may want to just make arguments, but certainly if they want to present documents or have testimony on this, I think you clearly should permit it and should consider it.
Good. Yeah, no, I appreciate that clarification. Yeah, I think we should consider anything, evidence or argument whatever they want to present. So that being said, what I would suggest is we open first with the Rogers Gumprecht, whether it's your counsel or however you'd like to, whoever's presenting your argument. But let's start with the argument being made in favor of the motion, argument and or evidence in favor of the motion to dismiss. And then we will hear from Mr. Marino on his opposition. And then we will also throw that open to any of the interested participants on that issue alone. And if we get past that issue and to the next issue, then we can take evidence as to the actual variance that's being sought. So let's start. I will open the floor then to the Rogers Gumprecht counsel, whoever is making the presentation on the issue of timeliness of the appeal only. And if it's counsel, Dale, you don't need to swear counsel in, is that correct?
That's correct, as long as they're not testifying.
Okay, and if it's Mr. Rogers or Ms. Gumprecht, we'll have to have them sworn in by the law director. So throwing it out then to the Rogers Gumprecht and potential counsel, who is speaking on behalf of the person moving for the motion to dismiss?
You could use the raise your hand function in Zoom. It will allow me to identify you. Steve Byron, I see.
Christy, you have the same problem with your voice you had last time.
I'll fix it.
You sound
That's
like
right.
Darth Vader with a sore
Yeah.
throat.
You'll need to use your phone again, I think.
Can you hear me now?
We can hear you
Okay.
now.
Yes, I see Steve Byron.
Great.
Mr. Byron, you are presenting, I assume.
If it pleases the board, I'll be the one speaking. I was going to say that Steve Patton had to do it, but he's not expecting that, so I'd be really surprised. I would just like to incorporate the facts that identified in the letter. The decision of the board, the Planning and Zoning Commission, was made on September 21st. I am finding out tonight that there was apparently a subsequent letter that went out from the village administrator. I know that your ordinances do not allow for the village administrator to extend any deadline that's set by ordinance. There is no provision which gives that authority to the administrator. And we would stand by our assertion that the 10th day after September 21st would be, October 5th is 14 days after September 21st. So the 10th day would have been October 1st, I think. October 1st, which was neither a holiday nor a Sunday. Those are the days which allow the appellant to have an extra day. And since the 10th day was not a Sunday or holiday, the failure to file the appeal by that date is jurisdictional, established by your Code of Ordinances, section 1111.03a, very clearly says 10 days after the decision. The decision of the Planning and Zoning Commission was made on the 21st, and that's the day that the 10 days runs. And the rules of construction support this argument. So there's also case law that holds that the failure to comply with statutory or ordinance deadlines is jurisdictional, and this matter should be dismissed by the BZA. Thank you.
Mr. Byron, what of the argument or of a potential argument that it would be reasonable for a party to rely on the date given by someone with the apparent authority to give them a date?
Yeah, there's case law out of the city of Lakewood. I think it may be the Fox case. Dale can check me on that. That was a case that involved the Board of Elections, and a Board of Elections worker gave a candidate the wrong petition to be filed. And the Ohio Supreme Court held that you cannot rely, I mean, the statute provides what the law is. You cannot rely on, there's no reasonable reliance on an employee, even one who should know what the ordinance or statute says. A similar case that I'm thinking of is, it'll come to me. There's a case, Miamisburg. Hortman versus Miamisburg. That's a case which held there is no there's no promissory estoppel in the operation of a governmental function. So I apologize. I didn't know this argument was going to be raised. I'm doing this off the top of my head, and I apologize not having these committed exactly to memory.
Okay, thank you. Does anybody from the board have questions of Mr. Byron? Going once, going twice? No. Is there anybody else? I assume that's the argument that the Gumprecht and Rogers are putting forth. I assume, Mr. Byron, there's nobody else who wishes to weigh in on behalf of your argument?
Well, if my client ever wants to speak on one of these things, I always let them. So I don't know that they have anything to add.
Okay, and again, we're not here to hear how horrible a house would be behind. At this point, we're not here to hear evidence about why we
Agreed.
don't want a house behind us or in front of us or anywhere else. So I give that a statement. But Mr. Gumprecht or Ms. Rogers, you're welcome to speak on the issue before us, which is whether the Mr. Marino's appeal was timely. Is there anything you would like to add? And I guess, Christy, you'd have to see if they're waving their hands.
Correct. And I see the hand raised of Mr. Rogers. I will unmute you and allow you to speak.
And then Dale, you have to swear in Mr. Rogers, please.
Okay, as soon as we get them on the screen.
I've given him access. It just takes a minute to come on.
Yeah, I can see, yeah, they're waving right now.
Yeah, this
Okay.
is Hope Gumprecht. I'll swear
I-
myself in.
Well, I got to swear you in, but
Yeah.
are you
okay.
speaking or is your husband speaking?
I will speak because I'm the one that handled the logistics of our initial appeal. So
Okay.
I'm familiar with the
All
10
right,
days.
I'll swear you in. Okay,
Thank you.
do you solemnly swear that the testimony you'll give to the Board of Zoning Appeals will be the truth, the whole truth, and nothing but the truth?
So help me God, I swear it will be the truth.
Thank you.
Okay, Ms. Gumprecht, the floor is yours.
I will just comment that after the initial P&Z meeting of May 18th, when we were instructed we could file an appeal, I went to the village website and looked for instructions. There is a form there that I downloaded. I read that, and then I called and talked to Rob to clarify the 10 days. So he made it clear to me it was not 10 business days as I had hoped, but 10 working days. So I just want to have that on the record. Thank you.
All right. Thank you. I assume board, no questions for Ms. Gumprecht? Okay, is there anybody else, Christy, who's out there waving their hand, wanting to speak in favor of or in support of Mr. Byron's argument, Ms. Gumprecht's argument?
Not that I can see.
All right, is there anyone, I guess I'd turn to Mr. Marino first. Whether it's you or your counsel, will someone be speaking and giving us your position on the motion to dismiss? I guess
Mr. Marino,
Okay.
are
Can
you
you hear
able to speak? Yes.
Okay. I will just reiterate,
I'm sorry, who's there?
this is Dennis Moran.
Oh,
Dennis,
and Dale will need to
I
swear
need
you
to
in.
swear you in. Yeah. We're getting a lot of feedback from somebody. Dennis, can you raise your right hand and solemnly swear?
can.
Do you solemnly
on.
swear? Sure. You ready?
Yeah.
Do you solemnly swear that the testimony you'll give to the board will be the truth, the whole truth, and nothing but the truth?
I do.
Are you able to, oh, there you go. Now we can see you.
Yep.
Okay.
Okay, Mr. Marino, the floor is yours. And again, we're just talking about the issue of the appeal here, please.
Right. I just want to reiterate, this has been a long, ongoing process from early this year. I've relied upon the advice on the procedures. I am not an attorney. And this is not an endeavor where we feel we can afford to spend thousands on attorneys and consultants to advise us in these matters. So I've relied on the village, Rob and Dale primarily for direction on this. And this, I must say, after this is our second time through, this is yet another example where I've been given bad information, you know, intentional or not, that is potentially going to cost us in the process. And I guess let's just say there comes a time when, you know, I got to say enough is enough.
Mr. Chairman, let me respond to something here. I don't give advice to applicants or residents of the village in this process. I don't give advice to anybody other than village officials, and I didn't do that here either. I understand Mr. Marino's frustration, and he has on occasion had conversations or emails with Rob that I've been on, and perhaps consider that to be advice of some kind, but certainly there's no actions that I took that would be something that he could rely on. I would understand the argument that.
Well, I would say that the direction of this entire process has been led by you, Dale, and it's been a circular firing squad.
I was going to say something that might have helped your position, but you interrupted me. I was going to say that he certainly could have thought he could have relied on the September 25th letter he got from Rob saying that you had 10 days or, you know, till the 5th.
It had a specific date in the letter.
Yeah, yes. And that's one of the things that the board has to consider is whether or not you believe that that's a basis for finding that you have jurisdiction if Rob put that in the letter to him.
Okay. All right, thanks, Dale. Thank you, Mr. Marino. Does anybody have questions for Mr. Marino on the board? Mr. Marino, is there anybody else that will be speaking with you on your position that you know of?
Not at this point in time, no.
Okay,
then, matter. Yes.
Good, thank you. Christy, can you open the floor for anybody else who would like to speak on behalf of our consideration of whether Mr. Marino is successful in fending off the motion to dismiss?
The floor is open. I would identify anyone who has their hand raised in the Zoom platform. I'll give folks a moment to respond. Currently, I see no hands raised. And again, after a wait, no hands raised.
Okay. Dale, I don't know if this is appropriate or not, and you'll tell me if it is. Counsel for Mr. Rogers and Ms. Gumprecht cited case law about the reliance upon a village administrator. Is there anything else that you can add to that? Do you believe that to be accurate citation of the law, and there's nothing else for us to consider as far as case law?
Oh, well, I agree with Mr. Byron's proposition that estoppel does not apply against local governments under any cases that I've read in Ohio. I've actually been unfortunately the victim of the bad side of an estoppel case in Mayfield Village many decades ago that we were in federal court on, and they were applying Ohio law. And since then, the Supreme Court of Ohio and the appellate courts in Ohio have consistently held that that local governments are not bound by the errors that they make or their improper interpretations of law or ordinance, and that an appellant or applicant has to do their own due diligence and their own research. The cases that Mr. Byron cited are not exactly the same situation here, where it's still within the administrative process of the village, but the principle or the concepts there, I think, equally apply. So I cannot disagree with his position, and I know of no case law that would be contrary to his position.
And I guess, thank you for that. And I guess to either you, Dale, or Rob, what is entailed in an appeal? What specifically is entailed for one to appeal a decision like was appealed here?
Submitting of the appeal application form.
And what is that? It's simply name,
Rob?
rank, and serial number kind of things?
Can you throw the appeal application form up on the?
I will do that. Give me a second to
Yeah.
find where that is, but I do have that.
It's right on the website. It's like the third thing down under applications and permits and forms.
Or Rob, you can actually put his application.
Well,
That's
that's
what he's
what
looking
I'm
for.
looking for right now. So give me a moment, please. Okay, here's the appeal that was submitted.
The language in the first two paragraphs are verbatim the same as in 111103 of our zoning code.
Okay. All right, thank you. And there's a fee I see of $100 that's filed with the appeal, is that right?
Correct.
Actually, I take my statement back. The last sentence in A is not in the zoning code, but the first sentence is, and the first paragraph is.
Okay. Any final questions, comments from the board?
Yeah, I have a procedural question, I guess. If this is denied, Mr. Marino's appeal, what are his next steps? I know he can't go back to P&Z and request it again unless he changes his plan. Is there any other option he has?
Well,
I assume he could get 3 members of council to take up
Right.
the issue.
Right. He can do that. If your decision becomes final and the council does not take this up, or the council takes it up and affirms your decision, then Mr. Marino could not go back to the Planning and Zoning Commission and ask them to start all over again and consider the modification request that he made on the lot depth to width ratio with the present lot consolidation configuration he has. He would have to have a different project that would be presented, because the law in Ohio is clear that he would be barred from raising that again administratively.
And I mean, Dale, you're, I guess, looking at this specific case, is there a way that he can look at those 3 lots and present it in any other way?
No, not with those 3. You mean with the way he's consolidating it?
Yeah, there's,
No.
it's not like, sometimes the homeowners can change the design of their house, move a foot here, a foot there, and it's a new application. This is 3 lots that you can't change.
Right, it's the boundaries of the land. He would have to acquire more land or different land to be able to accomplish a way around the res judicata bar that I just mentioned. Res judicata is a legal principle, and it comes out of a case out of Parkman Township in Geauga County, where somebody came into the BZA and they sought relief, then they went back again and sought the same thing again, and there wasn't enough difference between the first and second application, and it went to the House Supreme Court, and they said that you couldn't come back again and raise the same request. There's not a whole lot of law on what it takes to have a different request. There's a few cases out there, but not a whole lot of guidance.
Okay.
Okay.
Well, has that stirred up any additional comment or thought from the board? If not, what I would propose is that we take, and I guess, Rob, it takes the form of a motion. It would be a motion, as we always do, we take a motion in the affirmative and then vote aye or nay. But it would be a motion in the affirmative to grant the motion to dismiss filed by Ms. Gumprecht and Mr. Rogers, based on the arguments that have been set forth. So I would propose that we do that. Is there someone who wants to make that motion?
Yeah. So, I mean, I think I can. I'd be making a motion to approve the dismissal, I guess, of this. Is what you're
And
saying.
I think you should state for the reasons set forth in the letter that was, and the letter is part of the record, Dale, correct?
Yes,
The letter written by Mr. Byron.
yes.
So Jim, can you restate, just incorporating that, make a motion incorporating the reasons and the arguments set forth in the letter?
Yeah. Can I just say what Wade said? No, I'm just kidding. Yeah, no, I'd like to make a motion to, and the reasons for the motion are stated in the letter from Steve Byron. I don't know. I had that letter up, I just closed it down, sorry. But the letter that Mr. Byron stated for dismissing this,
There it is.
this application because of the section of our code 11-111-03 that says
It's actually 11-11-03.
11-11-03A, that the applicant must appeal a decision within 10 days. And so, yeah, there's my motion.
Okay.
Is there a second to that motion?
Go ahead, Dale.
Second,
Well, yeah, take your second. Then I was gonna say, in your motion, do you want to say that you're finding that the 10 days starts to run from the date that the Planning and Zoning Commission voted on the modification request?
Isn't that set forth in the letter?
I think it is, but I would rather have it affirmatively
Okay.
stated.
It is in the letter, and the Planning and Zoning made their vote, their decision on September 21st, 2020. And so the 10 days started on that day.
Thank you.
And second was by Lisa Kramer. So I guess we're up to the roll call. Rob, please.
Rocky,
Andrew,
So,
we can't hear you. I'm sorry.
I was just gathering my thoughts.
Oh, okay.
I'm gonna vote no based on, I think that the action starts when Rob sends the letter.
Freshman Johnson,
Rachel, you're muted.
Sorry, we're like reversing the appeal of the reverse of the approval and voting. And I just want to make sure I'm on the same page here. We're voting to support that the appeal is not allowed because it doesn't meet the days.
Correct.
Correct.
If you
So an
vote aye,
affirmative is denial.
Correct.
Okay. This is tough. If you look at the history of how I look at things, I'm a fact person and I'm the letter of the law, and it sets a lot of precedences, and it's ugly and it's gray. And I really do feel for people who fall within these issues, but the rules are the rules. And there's no law right now in our code that supports allowing this appeal to go through. And so I have to vote yes, due to the ordinance in our code. 10 days is 10 days from the decision, and that is not October 5th.
Frick,
I too am bothered by this issue. I generally would like to hear the merits of the claim, and I hate to just dismiss something on a technicality, but I would agree with Rachel. I mean, it says after a formal action, which might be a little unclear, but then under 111103A, it does say application for appeal from a decision. And it seems to me, if it's this important a project and you just have to fill out a form, I would make it darn sure I got in time. So I think it's a disappointing result in that we don't get to hear the merits, but I too tend to go by the words that were given to us. So I would vote aye as well, with some disappointment, but I think it's what the words say. So that's what I would agree, that the decision is the date that's important here.
Holdren.
Yeah, I kind of feel the same way. I was trying to find a way to allow this to happen, but I think our ordinance is pretty clear. So yeah, I'm gonna have to vote aye. That the application, the appeal was too late, past the 10-day mark.
And Kramer.
I'm also going to vote aye. On the appeal application itself, the applicant indicates the date of the action being September 21st. And I think the code section is clear as to when the deadline is, based on the date of action being the date of the original vote. So I would also vote aye.
Okay, so what this means then is the motion to dismiss has been approved, but as we have seen and as our code allows, 3 members of council can choose to have this decision by a 4-1 majority reviewed and potentially affirmed or overturned. So what I would say is, if no members of council, if they're not the 3 members within 15 days, then, and the 15 days is called out by the code, is from written notification by the clerk, 15 days after receipt of written notification by the clerk of council from BZA. So Rob, I assume you'll be getting written notice to council. When that's received, they'll have 15 days to have 3 members consider whether we've made in council's estimation, a wrong interpretation of the words before us. So if 15 days comes and goes and there are not 3 members of council who have done that appeal, then the matter will be closed. The appeal will be, the motion to dismiss will be granted, and the project as currently constituted will not be able to go forward. So I guess 15 days is the number now that we need to look at and see whether council opts to reconsider what we've done. Is there anything else, Dale or Rob or anyone else on this
Yes.
issue?
Well, you also have the variance appeal. So you'll have to decide whether you want to hear it or not. You have a couple of choices in that regard. And that is, you can say, because the lot consolidation has not been granted, there's no lot upon which you can consider a variance. Or you could say, should this come back from council and they were to reverse you, and you were to grant the modification and reverse the planning commission, that you could consider that tonight. I think the better course of action is to consider both at the same time. And I think you have the right to say that the variance for the lot depth is moot right now, because there is no consolidated lot upon which the variance can be requested.
I would opt for the latter approach, and I would suggest that if council reverses us, that we will do everything possible for Mr. Marino to expedite whether, you know, we have a full agenda coming up, and whether we have full agendas going forward. You know, we'll do everything we can to expedite it. If it has to be a separate meeting, we'll do that. But I would suggest that we that we consider those only if they're unmooted, if you will, by actions of council.
Yeah, the one thing that if you do that action, we want to make it clear that you did not hear it on the merits, so res judicata would not
Correct.
bar him from having that presented again in the future.
Is there anything other than the minutes of our discussion right now that we need to do that would indicate we have not heard the merits, and Mr. Marino has preserved his ability to make that argument should we be reversed?
I would put that in your motion. If you're going to,
the motion that we just made?
no, the motion that you would make now to decide that you're not hearing the variance appeal because it's moot, you would say that it's really premature because there's no lot consolidation that has been approved upon which you could act, or because the planning commission voted not to allow the lot depth to width ratio and the modification was denied, there is no lot consolidation that exists yet for you to consider the variance. I don't think the issue is ripe right now. And because you've denied hearing that modification denial, I don't believe you should hear the variance appeal because you don't know whether that lot's going to ever be consolidated as requested.
Can Mr. Marino just withdraw his application for the variance?
He could, but if he doesn't, it doesn't mean that he would be barred from having that heard again.
Can I reiterate here? We were approved at one point in time. Because apparently the law was misinterpreted, we were back again. The planning commission I was told one thing before the meeting. Planning commission was told something different at the meeting. So they were told that they could pass this on to BZA to approve it and they wouldn't have to act. That's why we had the change in the vote, to the best of my understanding, that it went from 3-2 in our favor to 3-2 against us. So I guess my frustration is beyond description at this point because we've been running around in circles for almost a year now.
Well, what we said at the meeting, and I understand what Mr. Marino is saying, and he's correct in this sense. What we said is that the Planning and Zoning Commission had the ability to defer deciding the lot depth to width ratio, and to say to you, BZA, you should consider the variance on the lot depth requirement before we decide the lot width to depth ratio.
Exactly.
And,
we have a chicken and egg scenario here and we're getting nowhere.
Okay, but the reason why I don't think that argument prevails today is because they chose not to do that and they actually voted and denied the modification.
Did they understand it at the meeting? I don't think they did.
Well, I disagree with you. I think they did because we explained it to you, but we're all speculating. I can't tell you what was in their minds. But
I would like a clear, concise path to do this type of project that we can follow one time. We've gone through this now. Like I said, this is our second time through the whole process. We've been going on all year. We've been approved, we've been disapproved, we've had appeals denied, we've had appeals approved. You got to understand, does not look real good for the village.
Well, my understanding, and Dale, correct me if I'm wrong, believe me, Mr. Marino, we share your frustration. We thought this was resolved once and now it's back before us. And we understand from your standpoint as a consumer, if you will, of our code, it can be frustrating. It sounds to me like the path forward is you have to now go to council and say, council, I've been wronged. They screwed up the interpretation of the appeal, and you should reverse them on that and send it back. At that time, it seems to me that we would then be considering the variance that you have requested on the factors set forth in the code, the Duncan factors that we use on every variance. But Dale, is that correct? I mean, it seems to me that's the path forward, and I'm sorry for you that you've been appealing and been appealed and all this stuff. It's rather confusing to all of us, but that's where we are right now. That you need to go to council and see if council is going to tell us that we got this wrong, and that we should then consider your variance request.
All right, well
Actually,
now, Dale, tell me this, if, because of this, because I relied upon the date that was in the letter that Rob sent me, and granted, it was both of our parts an honest mistake, can council overturn that, or do they have to write a new code to allow me to proceed?
if 3 members of council petition to have this heard by council, council can reverse the Board of Zoning Appeals decision tonight to dismiss the appeal. They have that power to do so.
They can waive, in effect, despite the confusion and COVID and all this stuff, that 10-day thing, they can override. That's what I want to hear, loud and clear.
If they believe that the Board of Zoning Appeals was in error and
That's not the answer. That's not an answer.
Well, I'm not giving you the answer you want. I'm giving you the answer.
No,
that's
I
right.
want a straight answer. That's all I want. Can they do that? Well, can they override the code?
I've already answered that. Can they override the code? No, they can't override the code. They can reverse the decision of the Board of Zoning Appeals if they find that the board incorrectly interpreted the zoning code. They wouldn't be able to pass legislation now that would be effective for when you filed your appeal. They couldn't retroactively grant a change in the code to allow you to appeal. And to amend the code, it's got to go to Planning Commission. They have to consider it, make a recommendation. It's got to come before council and have a public hearing. You're talking about a number of months before anything could happen. And if they did that, it still wouldn't help you. The only remedy you have within the village is if you can convince 3 members of council to hear this and determine whether or not the Board of Zoning Appeals should have granted the dismissal or not. They can't override the code, but they could say that the 10 days didn't start to run when the vote of the Planning Commission was made, or they could say that in their opinion that you should have been entitled to rely on the letter from Rob. There's a number of options they have, and that's they do have the power to do that. If that occurs, then whoever is the losing party will then have the right to appeal that to court, and ultimately a court could make the determination as to whether the appeal should have been dismissed.
Well, that sounds like where we're all ended up.
We hope not, but if it is, it's beyond my control.
Like I said, numerous incidents over the last 6 months have left me very disappointed and disillusioned with the village, I have to say, after almost a lifetime resident.
All right. Is there any other matter before the BZA tonight? I believe this was our only issue. Is there anything else?
You have to decide about the variance. You got to make.
Oh,
a motion.
I'm sorry. Yeah, we need a motion. I'm sorry. Yeah, thank you, Dale. Is there someone who can make a motion? Would make a motion, and I assume we would do it as Dale was outlining. It would be a motion to defer consideration of the underlying other related variances until and if we need to hear those.
Yeah, I would like to make a motion to defer the variance request because we cannot hear the variance request at this time.
Is that enough, Dale, to preserve Mr. Marino's
Well-
right to raise that?
Well, you're not, the way the motion's made, you're not denying the appeal, you're not dismissing the appeal. What you're really doing is you're tabling it. You're leaving it for consideration for another day. So that clearly would not impair Mr. Marino's ability to have that issue ultimately heard if this matter comes back before you.
Okay, so then is Jim's motion as said sufficient?
Yeah, as long as you clearly all understand this isn't a dismissal, it's a deferral of the issue.
Absolutely.
Okay,
So is there a second?
Second,
Okay, Lisa Kramer with the second. Roll, please.
Commissioner Johnson.
I vote aye to approve the motion to defer any discussion or review of the appeal, thereby reserving his right to do the variance appeal at another time.
Frick.
I vote aye as well to preserve Mr. Marino's right to argue the merits of the variance request, should that be put before us by action of council. So I vote aye.
Holdren.
I vote aye.
Kramer.
I vote aye to table the variance, the appeal of the variance, or the variance request for now until we get a full understanding of what's going to happen next.
And Rocky.
I vote aye.
So now 3 members of council can tell us we got that wrong as well. And no, I'm just kidding. Okay, thank you. Is there anything else to come before us tonight? We do have our regular, I'm sorry, Rob, you said something?
I do want to say one thing to clarify or to summarize all of this. Every effort that we've made in my office and with my staff and working with Dale is always meant to thoroughly review any proposed project and to, as efficiently as possible, guide it through our approval or our review process and through all of our boards. We do that with great care and great diligence to make sure that we don't make errors. We are human. We do make errors on occasion. In the issuance of the September 25th letter to Mr. Marino, I was attempting to clarify the matter as clearly as possible in the process to move forward. For whatever reason, the date was incorrect in that letter. I don't recall whether that was a typo or whether it was a misinterpretation. I don't believe that was, it clearly was not the intent. The intent was always for both the applicant as well as the appellants to make sure that every document was presented in a appropriate fashion before any board that they have to come before. So I just wanted you to know my opinion on that. I fully accept responsibility for any mistake that may come out as a result of actions of administration. And we always seek to refine that and seek to look for ways to develop our zoning code to make this process clearer and more efficient. I'm welcome to any suggestions or input from anyone on the board at a later time. Please reach out to me.
Thank you, Rob. You do a great job with all you have going on. So we appreciate your comments. We appreciate Mr. Marino's rights, everyone's rights in this matter. We'll do everything we can. Council will now potentially consider where this needs to go. But Rob, you do a wonderful job with a lot of things. So thank you. So nothing else before us. This meeting is adjourned. Our next meeting will be November 24 at 7:30 p.m. Thank you.
Thank you, everyone.
Good night, everyone.
Bye-bye.